Morning everyone, I'm Dr. Manasa, Assistant Professor from Institute of Aeronautical Engineering, Hyderabad. I'm going to talk about the laws that are related to the women protection. So, what are those laws? Let us say. So, women rights are the rights that entitlements are claimed for the women and for the girls of many societies of the worldwide, and are formed on the basis to women's rights movement in the 19th century and feminist movement during the 20th century, so as to make the women empowered and then come out of the discrimination or the obstacles that are facing. So in the 19th century as well as the 20th century, the feminist movement has happened. So from there onwards, the laws or the rights have been developed so as to protect the women against the acts violence. In some countries, these rights are institutionalized and they are supported by the law as well as the local custom and behavior, whereas in other countries they may be just ignored or suppressed, because though as namesake the laws are there, but still the continuation or the following of the law according to the society which is following the laws may not be there in many countries. Just for the namesake, the laws or the courts are there, but in many countries, the developed countries, they are spread everywhere to the institutions as well as the workplaces, and then every system has to follow the laws, and according to those laws and the custom only the things have to be followed, and they differ from the border of notions of human rights through the claims of an inherent historical and traditional bias against the exercise of rights by women girls and in favor of women and boys. So the laws are constituted by the government or the human right authority in order to protect the women and in support of like it should be in favor to the men and the boys also, but to protect the girls against these violences or the harassments. So such laws are the rights have been developed. So the issues commonly associated with the notions of women right include, though are not limited to right, but they are limited to bodily integrity and autonomy, to be free from the sexual violence and from the voting, and to hold the public office, that is at workplace, and to enter into the legal contacts, and to have the equal right in the family as well as and workplace, and also the two fair wages are the equal play at the workplace, and to produce reproductive rights, so means they should have the same payment, or the pay shouldn't be unequal. So someone has to see the performance of the person, but not based on the gender, and it is to the own property as well as for the education. So the rights have been developed based on all these, either from the harassment or in order to have the opinion of the girl or the female in the society, like voting or to enter into the politics and to have the legal officials. And then in terms of the family also, like what place they are in, as well as at the workplace, they should have the fair wages or the equal pay, and then they should have the reproductive rights, and then in terms of having the property as well as to get educated. So these are all the main the concepts based on which the rights have been developed for the women empowerment. So in this section, which deals about the laws that are related to the women issues, so what are those laws? Let us see. So this coming to the first law, which are related to the laws that are related to the dowry. So the Dowry Provision Act, that is at 1961, it has been developed, which is amended by the Dowry Amendment Act, which is being developed in 1984 and 1986. So what is this else? So what is this dowry law is saying is dowry means any property or the valuable security are agreed to be given either directly or indirectly during the marriage. So like this, the concept of dowry initially maybe it was to the having the highly rich people to give to their daughter or the girl child to some property, but the later on this act has become like it is a must, and it is being continued over the generations, but it is not particularly confined to the only money or the valuable things. So it is said about the complete valuable things or the security purpose, or it is in terms of some property also. It can be either directly or indirectly given during the marriage. So by one party to a marriage to other party to the other, it is giving of the property to one partner to the other party of the marriage system, or by the parents of either party to a marriage. So it is like giving one of the parents giving their money or the valuable things to the other parents in a marriage, or it can be by any other person to either party to the marriage and any other person at or before or any time after the marriage in connection with the marriage of said properties. Like it can be given in during the time of the marriage, or it is like they can give after the marriage, but it is like we agree for this much property and then we give. So it is the that is the term the dowry means. And what does this Dowry Prohibition Act says? Let us see. The punishment of is for giving the and also taking the dowry, or abetting the giving and takeoff of dowry was earlier punishable by the imprisonment up to 6 months or fine up to the 5,000. So giving dowry itself is a punishment. It was previously, and it has a punishment like imprisonment for the 6 months, or you have to give the fine of 5,000 rupees, and demanding dowry directly or indirectly from the parents or the guardian of the bride was also liable for the similar punishments. If someone demands for the dowry from the either parent or the guardian of the bride, then they are liable for this kind of imprisonment, or for the in terms of fine up to the money. And then this punishment was later enhanced by the Amendment Act, and these offences are being punishable with a minimum of 6 months and a maximum of 10 years of imprisonment. So this later this punishment has been extended with based on the severity of this issue. So it can be from the 6 months to the 10 years of imprisonment. The fine limit has been enhanced to the 10,000 to or to an equivalent amount to the dowry given or demanded, which is more. Look, it can be like how much dowry that bride has given, or you can pay the 10,000 rupees amount as a fine. So the fine amount also has been extended. The court has been given the discretion to reduce the minimum punishment, though in doing so, the court is required to record the writing adequate as well as special reasons for doing so. Like if you have put the case, then it has to means if the punishment is given, if it has to decrease the punishment, then you should give a proper adequate writing document, or the like you should have a proper proof in order to decrease the punishment, otherwise the punishment is not at all decreased. So this comes under the section 3 and 4 of the Dowry Prohibition Act 1961. The amendments have been brought about in the Dowry Prohibition Act to remove the defects which are existed in the main legislation. So the aim of the this Dowry Prohibition Act is not to have the punishment or the to get the money from the people, but it is the aim is to decrease the number of cases which are having this dowry cases. So make them more educated that to not to have the issues as the for the dowry cases, so as to not to allow first of all to take the dowry. And the Ministry of Women and Child Development, so that is called the MWCD, is seeking further amendments in existing provisions of the Dowry Prohibition Act 1961 in order to provide more teeth to the dowry provision law. So this women and child development is also providing some provisions for this, so that both are linked, and let us not have the more number of cases, but instead you decrease the number of people that are taking dowry or affected after the because of this dowry cases. So the protection to save the girl child, or have the effects of the marriage. So that has been interlinked with the women and child development. In 2019, National Commission for Women proposed some changes to this act. So, for this Prohibition Act, it has linked to the National Commission for Women, so which is proposed in which in 2019 it has proposed some changes to this laws. These recommendations were discussed in interministerial meeting, and the Dowry Prohibition Act bill, which is released in 2010, was drafted in consultation with the Ministry of Law and Justice, because at the last you should follow the justice or the law. So someone has to go to the court and then get the punishment. So it is linked with the law and justice, and then this National Commission of our Women is being interlinked, and then it has said some kind of changes, and they have put this bill in 2010 in the interministerial meeting. So let us see what are the types of the dowry offences, means what cases can be there to have these dowry laws. So one can be, it is the torture due to the dowry, and which comes under the penal action, the 498-A by 34, or it comes under the IPC section 4 and 6, which is the DP Act. So what are the things that come under this dowry torture are which are if the subjected cruelly by the husband, if the bride is being subjected cruelty by the husband or the relations of the husband, there must be marriage and torture within 7 years of the marriage, and demand for the dowry before, or can be during or after the marriage. So if the effects are these, then this come under this um, section, means this case. And then the next one is dowry torture with attempt to the murder. So if this has to be the case, then it comes under the 498 A by 34 by 307, and which comes under the IPC 4 IPC and 4 DP Act. So which are can be all these that we have, means there can be any, means the harassment from the husband or the relative sides of the husband, and can be due to the torture for the getting dowry from the parents, and also this in uh, other than that, there can be attempt to commit murder by doing any of these offensive things such as burning or hanging or poisoning, or throttling or stabbing. So these can be there for this. Then that comes under this case, which is a dowry torture and with attempt to the murder. And then next one is dowry death. So if death happens because of the dowry issues, which comes under 304-B by 34 IPC section, and then death of a bride within 7 years of marriage. So if it is happening, so then it comes under a dowry death. So if this happens, so then what could be the punishment from the government is, this can be the death of the other person or imprisonment for the lifetime. So either you have the death of the person who is harming that dead person of the bride, and then if the case is dowry murder, dowry death murder, then it comes under 498-A and 304-B and 302 and 34 IPS. So it can be it is death of a bride within 7 years of the marriage, and then the death sentence or the imprisonment for the lifetime. So if the murder or the death of a bride or the lady wife is due to the dowry harassment, then the punishment is to have the lifetime imprisonment or the death of the other person. And abortment to commit suicide. So if this is the case, and then it comes under the 498-A by 306 and by 334 IPC and 4 DP Act, which also is if the means bride has been attacked within 7 years of the marriage, then the imprisonment extend to the 10 years and with the fine of a certain amount. So these are all the rules which comes under the dowry related act. And let us see the another act which is called laws which are related to the remarriage. So what is remarriage? Remarriage is allowing women to remarry after the death of the spouse, or if she or he means divorce the spouse on proper legal grounds. If she is being divorced with the spouse with a legal grounds, or if the husband has been expired, then that person means that widow can allowed to get remarried. And then the Hindu Widows Remarriage Act has been developed in 1856, and also Act 15 in 1856 enacted on 26th July 1856, which is legalized the remarriage of Hindu widows in all jurisdictions of India under the East India Company rule. So in the previous Indian customs, the widows have been treated very means they are not allowed to go out, or they are restricted to some place. And if husband is expired, means they have been thought that she is limited to some room or the home, and then she's not allowed to go out at all. And then there were some customs to have the mandan, or she wears a white sari like that. And then yeah, there were before kind of sati sagam and all. So this Johar and all were there in Rajput families as well, so that we have discussed. So those things have been changed by the generations, but still these the Indian mythological feelings, or the and things have not been changed over the generation, but still are existing. So as to stop them and allow the widow to get remarried, these laws have been put and then improved, so that she can have another life. So to protect what it is considered family honor and family property, and upper caste Hindu society had a long disallowed the remarriage of widows, because they had all customs that once husband is expired, means you sit to this place, and then you be the part of this, means you be here only, and then do not allow for any outside the ceremonies and all. So in order to have this kind of family properties, or that and then first of all, Hindu society people did not allow at all, means they didn't accept these rules to get remarriage of the widows, and even child and adolescent ones also, if the bride is very young, and then also they didn't allow. So all of whom who were expected to live in life in austerity and ambiguation. So these happened initially, like always this comes a repulsion when something has new started. And then the Hindu Widow Remarriage Act of 1856 is enacted in response to the champion of Pandit Ishwar Chandra Vidyasagar, who provided the legal safeguards against the loss of certain forms inheritance for remarrying Hindu widow. Though under this act, the widow forsook any inheritance due to her from her deceased husband. So, though this widow did not want the properties from that deceased husband, but still the people were disallowed to go for the remarriage. But the person, the Pandit Ishwar Chandra Vidyasagar, he has provided some safeguard rules that some property can be allowed for that. And then like if the person is expired, and then some of the property of him can be given to that widow wife. So he has provided certain um, rules and regulations, and especially targeted in the act where Hindu child widows whose husband died before the consummation of marriage. So if because in the earlier in the Hindu system, the child marriages were many. So by the time the girl grows, she becomes young. But then husband would be of some 80, 90 years, and then he expires. So by the time she knows the what is this world, and then she becomes a widow. So this person, the Pandit Ishwar Chandra Vidyasagar, has especially focused on these kind of the child marriages, the widows which are being growing because of the child marriage. So for that, those sake, he has push up, means he has had a strong focus on them, and then developed this remarriage, Hindus Widow Remarriage Act. The Hindu Widow Remarriage Act of 1850 validated on widows remarriage. So it focuses on the remarriage of the widows. So what are those features of this act? Let us see. When the widow remarriage and the children born of such marriage have been declared as a valid, and after remarriage, widow loses the right property over the properties of her deceased husband. So once you are remarried to some other person, then you have no right to have the ask about the properties that the deceased husband. There are two views in regard to these rights of widow over the properties of her deceased husband. If she changes her religion before her remarriage, so in the view of various high courts conflicting this regard. In case if a widow is a minor, then she have to obtain the permissions from her parents or the guardians for remarriage. So at very young age, for example, before the major before 18 years itself, then she has to get the permission from the parents to get the remarriage. And in addition to these provisions, Hindu Succession Act in 1956 and Hindu Marriage Act in 1955 also contain some provisions which are related to the widows marriage. So, in conjunction to this Hindu Succession Act as well as Hindu Marriage Act has been developed. This is the laws related to the Hindu Marriages Act as well as the Dowry Prohibition Act. So let us see some more laws in the next session, and then thank you.
Like, share and subscribe. Hit the bell icon for more updates.